Top 10 Things to Do for a Meaningful Mediation, a conversation with Patrick Russell. That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac PLV, attorney, mediator, and arbitrator working throughout Florida and Texas. And today I'm with a Florida attorney mediator who is named Patrick Russell. And Patrick, how are you doing today?
I'm doing excellent. Thank you so much, Mac.
Yes, sir. Thank you so much for coming on to talk to us about top 10 things to do for a meaningful mediation. You've been a lawyer for, 30 years? You've been mediating since 2009, and you've just had a lot of different experiences over the years. So I wanted to have you on to just talk about your mediation practice and some tips that can be of help to lawyers and the parties, people who come to you for mediation or who go to any mediator to make sure that it's going to be an actual effective mediation and not a waste of time. But first, tell us about yourself and a little bit about what you do.
Well, Mac, I'm a Florida certified circuit and county court mediator, certified since 2009 here by the Florida Supreme Court. My experience as a lawyer goes back 30 plus years, really heavy in commercial litigation, insurance claims, personal injury, etc. Now as a mediator, full-time mediator, those are the type of matters that I handle, also including construction claims and things like that. So I've had experience on both sides of the aisle, which I think is pretty useful when you try to mediate.
Yes, sir. And so on your website, there's a lot of photos of you out on the water. So you're based in Florida, and are you in the Miami area?
Yep. Live and
Okay.
work in Miami, Florida.
Yes,
Been
but
here since 1990.
yes, but since you are virtual or remote in many ways, are you mediating everywhere?
Everywhere in the state of Florida. Cases in the state of Florida, but I've mediated all over the place in terms of even where I'm physically present can be in many different places.
Yeah. All right. Well, something we have in common is that we both like to mediate from anywhere. And so you recently came on to Instant Mediators, and it's great to have you there because it's a place where we believe that mediation should be something that is spread out, touching as many people as possible, and something that can be done quickly without taking too much time. But all right. So the topic, for today is top 10 things to do for a meaningful mediation. And what do you mean by that, first off? And we'll go through some of the points, but what do you mean about meaningful mediation? Why is that important to you? And then give us one of the points.
Okay. Well, for me as a lawyer, when I would go to mediation, I always found it frustrating when I would go to a mediation and it ended up being what I would call a waste of time, right? So what's that? One, nothing is learned, not a lot of exchange of information. People are not maybe prepared to resolve their cases. Mediators not encouraging people to share information. And the mediator ends up becoming a person that just runs between the rooms with a notepad and numbers. And I never found that to be real useful in terms of trying to analyze and bring the people together and do problem solving. So in my mind, and that's why I created my website, Meaningful Mediation. I have a logo about meaningful mediation. I have a challenge coin about meaningful mediation. It's something dear to my heart where I think the parties are owed something, where they learn something, they understand the positions, and they get to their bottom lines, and they try to do some real problem solving at mediation. So that's what I think a meaningful mediation is.
Okay. And so you prepared a little bit of a list about the points that make for a meaningful mediation. And number one, schedule the mediation when the parties are actually ready to mediate. Can you give us an example of how this is a problem?
Well, it's critical. I mean, let's just start from the very beginning. If a party's not ready to mediate for whatever reason, it could be that one party really, and this is an example I see a lot, they really need a hearing and a resolution of a pending motion for summary judgment.
Yeah.
It's going to make or break their assessment of the case for some reason, one reason or the other. If they mediate before, chances are they're not going to do much because that's really what they want.
Yeah.
And at that point, then they can analyze, okay, if it's not been granted, right, then we got to deal with this pending trial coming up. So now we can start doing a risk assessment of how to really make the case go away. That's like one instance where I see that a lot. So you really need both parties to be ready. Or another one is they haven't exchanged, even some basic discovery.
Yep.
So they don't know what the heck is going on in the case, what's supporting the various positions or damages. That could be in a homeowner's context with an insurance claim. There hasn't been an inspection. How are you going to assess liability or damages without some of these critical things? So both sides should be ready and know what their positions are and be able to support them at a mediation. So that's kind of the right time.
Yeah, no, the discovery one is big in my own personal practice. I've done a lot of family law discovery, and you find yourself sometimes scratching your head as a mediator when people come to you. Basically, they don't have any information exchange. If we had to do a lot of recesses where we say, you know what, why don't we table this case for another month or so, come back to the table, and then we'll keep the negotiations going. But absolutely, that's a big one. Schedule the mediation only when people are actually prepared. But before we go to the next one, do you think that can be taken to extremes to where people think, you know what, I'll mediate only when I'm ready? But will you ever truly be completely ready if that's the standard?
That's a really, really good point. And that's a pushback that sometimes people make is like, listen, we'll never really be ready. However, for the purposes of resolving a case, do you really need everything? No, because there's no certainty. If you want certainty, that's what the trial's for.
Yeah.
But to resolve the case, both lawyers need to analyze, okay, what do we need to resolve the case? Like, you don't need to know everything, right? And that's also one of the mantras that I have for lawyers is you need to come to mediation prepared to settle.
Yep. So that's
And
number two.
oh,
Yeah.
well, I jumped ahead, right?
Yep.
So that's the natural
Yes.
segue. And so what does that mean? You mean you have to have an intention. So you have to understand what is it that what does the other party need for them to resolve? So what information can I give to them and that they can then assess the case and figure out what to do about it? Holding things back is not going to help.
Yep. So that's number two. Prepare for mediation with the intention to settle. Okay, number three, prepare your client for mediation and manage their expectations. This one's a big one dear to my heart, managing expectations. So
Yes.
tell us more. Why is this important in order to make sure the mediation is meaningful?
Well, oftentimes you will see clients that appear at mediation. It's unfortunate. They may have never met their lawyer before.
Hmm. Yeah.
And the first time is at mediation. And they may not even had a discussion before the mediation about what's going to happen during mediation. So it's kind of an uncomfortable feeling for the client. Not only do I, as a mediator, need to help them along, but they haven't been apprised as to the process, but more importantly, the possible outcomes for their case. And this is where it goes to expectations. Sometimes, you can't have clients think of the pie in the sky idea. They see billboards these days,
Yep.
lots of them about $1 million cases and settlements. Not all those cases are like those cases. So you need to manage the client's expectations realistically of what the possible outcomes are for their particular case, so that when it comes time to discuss numbers and negotiations, there's not this pushback of like, why isn't it more? Or my neighbor or my priest or somebody else has said, hey, this is what your case is worth. The lawyer should be able to do that for them so they have a good sense and control over their own case.
Yes, yes. I know that lawyers are often busy and they don't have time to prepare their clients as they should. Sometimes lawyers might send you a pre-buttal, or a statement, a write-up telling you their wish list of things that they want, to happen or what they hope will come out. Just give you a bunch of facts. I love when lawyers send that to me before the mediation. It prepares you as a mediator. But although that would be great for lawyers to send you all that information, sometimes the opposite happens where the lawyer sends you nothing. And you're having to spend a lot of time basically getting the client ready to mediate at the mediation table. And so I think that's big part of number three: prepare your client for mediation. Absolutely. And as far as managing expectations, you know you said the billboards example, right? You're driving down the
Mhm.
freeway all day long and you see the $1 million cases and the person thinks that's what they're going to get. Well, maybe not.
No.
Yeah, and so what in the law we call that woodshedding, right? Where the lawyer takes a client out and kind of woodsheds them before they go to a hearing. I think the same kind of thing needs to happen before the mediation begins. Tell your client no, let your client know what's going to happen, or likely not to happen, so that they're not completely shocked and surprised.
Because
Okay,
they're going to hear different numbers from the other side,
yeah,
obviously.
you're going to get pushback. And sometimes the pushback is a reality check that they're getting for the first time. And it's probably better to get that from you as an attorney. Certainly will make for less awkward moments and not, turn it into a blame game where the client who might be a little irritated turns on their lawyer, because I've seen that before.
Well, there's
Okay.
another component to this too. It's like a psychological component, which
Yeah.
I'm a big proponent of analyzing that perspective.
Yeah.
Is that if you prepare your client and say, listen, this is where we think the case could go, but I'm going to start at X
Hmm.
and hope to get to Y. If you don't do that type of work with them, when you start at X and start moving down towards Y, every one of those concessions
Yeah.
seems like a big
It's
loss to them and they
painful.
feel like they're losing lots of money.
Yep.
But if you prepared them correctly, they know it's just part of the negotiation process. It's not a loss because people fear losses more than they do gains.
Yeah, exactly.
It's
No.
a
Yeah.
psychological
Yep.
reality.
Yeah, loss aversion, right? I mean, we see all the studies, about the kid and trying. It's at the Halloween front door, and you do the studies that show if you take candy away, the child feels it more, and so it's just human psychology. And so I wish that loss aversion theory and managing expectations was something that we taught more in law school, especially now that conflict resolution is becoming more and more popular before cases go to trial. So lawyers need to be schooled on this. It would certainly help them with their client relationships, I think.
Yes. And in
Okay.
Florida, all cases have to go to mediation before they go to trial. I'm not sure
Yeah.
if that is the case in Texas as well.
Yeah.
So we
Yeah.
need to
Very
do that.
similar. Yeah. We've codified a lot of these in the rules, pertaining to getting parties to the negotiation table, because it oftentimes helps streamline, judicial efficiency. We're burdened. Our courts are busy, and we can't afford to have trial for everybody when people could just talk it out. Okay, number five. Build number four. I'm sorry, getting ahead of myself. Number four, build rapport with the parties. So, how does that make for a meaningful relationship, meaningful mediation?
Well, there's a saying that I have, and that's not unique or anything that I created or original, but essentially the idea is that solving the people problem, because in mediation that's often the case, right, with the parties. The parties are the bigger problem than the legal problem. If you can solve the various emotional tendencies of the parties, maybe they have different issues and perspectives. Maybe there's a past relationship issue going or history. Like there's a lot of difficulties that people bring into mediation. But if you can get through all of that and solve and figure out how each person works differently, Some people are visual oriented. Some people work on words and verbal, tactile. I mean, there's all these differences in people.
Mhm.
That's just them individually. And then together and amongst each other, if you can solve the people problem, the legal problem is much easier. And how do you do that? You have to have the parties be able to get along. They don't have to like each other, but they have to respect each other. That's what rapport is all about, so that they work together. That's the essence of mediation. You can't solve a problem by one person, right? It can't be unilateral. So you
Correct.
need them to work together. How do they work together? They're more prone to work together when they at least respect each other, see each other as human beings rather than as enemies, villains, or the enemy.
Yeah. So, who would you say is the audience for that specific advice? The build rapport with the parties. Is it for the mediator? Is it for the lawyers? Or
It's everybody. If any one of those, if the mediator is off balance, right, that's not going to be helpful. As a mediator, you are the role model. People will mimic behavior.
yep.
So that's why I think it's really critical. And I use a little humor during my mediation. I keep mediation light and but focused. But they will mimic your behavior. And same thing goes with the lawyers. If you see an aggressive, angry lawyer, their clients will tend to be aggressive and angry,
Yeah.
right? So if you can build a forum, a place where everybody is kind of cool, calm, collected, and willing to make a deal and to try to solve problems, that's the ultimate place where you can try to actually get something done. So it's upon everybody. The lawyers have to be able to do this, the clients have to be able to do this, and the mediator has to do this. And this is something I touch upon during my opening as well, during my mediation, so that we all kind of get that buy in.
Yep. And so, when you start your mediations, are they always together in one group? Right.
Uh, no, so I've recently changed where I start my mediations separately, and this is where I build rapport with people.
Yeah.
I get to learn more about their case, even though I've already prepped it and looked at it, but I get to learn more. There's always some nuance that you can't gather from what people send you or when you talk to them the first time. But when
Yeah.
you're with mediation, they're all together and you can really, you treat them as somebody that's caring and you want to help solve the problems for them. And it loosens them up, right? They're not so tight and rigid anymore. They're more amenable to negotiating, right? And trying to fix problems. So that's why I do that with each side separately. Then I bring them together. We have our joint session and I go over a lot of the things, like at least 5 of the things that I have on my top 10 list, I discuss openly with them as kind of keys and tips going forward during mediation to keep in mind.
Got it. So, build rapport with the parties. All right. Number 5, have a negotiation plan and know your settlement number. Okay. How is that important for meaningful mediations?
Well, if you come in and you have no idea where you're going, you have this, for lack of a better word, a pie in the sky number that you think this is what you want to get, but you have no idea really how to get to that place, or you don't even know your bottom line. You haven't figured that out. You don't have a plan with your client. It is just kind of making it up as you go along. That's not a real good recipe for success for negotiation. You should have a plan. You should know that this is where I want to start. I
Yeah.
definitely know what I need to know, and I need to confirm with my client where we want to end. Preferably, they also would like to know, if that's where we end, how much do I get, right? We always have those conversations that you'll see those in mediation where the client's like, what's the bottom line? What do I get out of this, right?
Yeah.
That should be done in advance so they kind of know. And then how you get there. What moves are you going to make to get to that bottom line? You don't necessarily want to do it haphazardly. You don't want to do it randomly per se. You should have a plan and you want to be proactive. You want to control your own negotiation. I always tell people to negotiate to the march of the beat of your own drummer, right? I think Thoreau said that,
Yeah.
right? So don't be reactive to what the other side is. Often you see people do the tit for tat back and forth, right?
Yeah. Oh, yeah.
I'll
Yeah.
go down
Exactly.
500, you go down 500. No, get to your number. The sooner you do that, the more efficient the process will be. And let's see if that's a good decision for somebody or not.
Yeah. So sometimes, not wearing my mediator hat, but when I'm an attorney and I'm going to be going to mediation with my parties, of course, I always would shed them and have the conversation about, look, here's what to expect. And so they can feel comfortable about the process. But I do ask them for red lines. I'm like, look, what's your red lines? What's your
Mhm.
limit? Because we're going to go in there. We're not going to just put everything out there, but I need to know what are my marching orders. And so, absolutely, have a negotiation plan and know your settlement number. Okay.
And this is also where rapport comes in.
Mhm.
If you build a rapport as a mediator with the lawyer and the client, and that they trust that you have their best interests in heart to try to help them,
Yep.
they're more prone to share that bottom line with you than otherwise, right? Sometimes, I mean, you don't necessarily always have a mediation with a party that you've mediated before, right? You
Yep.
have mediations with a lot of new lawyers.
Yep.
So they don't know you per se, but if you build a rapport with them and they can trust you, which I hope they do, right? That's why
Yep.
they hired you. Then
That's
they're
key.
more prone to give
Mhm.
you the bottom line and you can do your job more effectively as a mediator.
Yeah. Good point. Getting people to trust you from the, you know, sometimes it's not clear in the beginning. Again, they don't know you, they're feeling you out. But if the person from your opening statement, hears something that they like and they feel comfortable with you, and then they can, and you're approachable, I think absolutely that's more likely than not to get them, to just move this thing along. Let's get right, to it.
Mm-hmm.
Okay. Number 6, start negotiations with a reasonable offer. So this one should be good. Yeah, because some people have just flat out been insulted by a number somebody might start off on. If we're negotiating a number, sometimes we're negotiating, custody questions or other things that you can't really quantify. But I guess you can quantify everything, whether it's child support or possession and access. I'm doing more, family law mediations these days. That's kind of why I say that. But I've just heard people just take offense to
Mm-hmm.
where, and when offer is made, the other person thinks that the other person's being, non-serious. And so, why do you think that's so important about having a meaningful mediation?
Well, when people start off with a number and that, one that has no relationship to necessarily reality, and they're throwing the number out and they know seriously it's not a real number, but they figure that this number, one, maybe it's shock and awe, or
Hmm.
maybe it's they want to have that number so that they can then get to the real number, but they're planning like a whole bunch of moves in between,
It's games.
right?
Yeah.
Um, the problem with that is that that can spin the other side off.
Hmm.
And as a mediator, I might need to spend another 30 minutes to an hour trying to unwind the other side to keep them engaged. So it's unsettling, it's not helpful, and it really throws the process off. In some cases, some people will, it hasn't happened to me yet, but some people could literally just walk out based
Yeah.
on the first number.
Yep.
So it's really important to have a reasoned number, a number that somewhat makes sense, and it's not going to throw the whole process off.
Yep.
And that goes
Absolutely.
whether it's high or low, right? It goes on the other side too.
Yeah. Yeah. Because if you start off really low, the other side might think, "Oh, I got this," and then before you know it, their number that they were going to counter propose seems really high, and then it's going to create all sorts of issues. But I wonder if there's a difference, between when you mediate with lawyers and their clients versus when you mediate with pro se's, or do you not do pro se's, people without lawyers?
Not often. Most of mine involve lawyers. Most of my
Yep.
cases are circuit civil cases. Those tend to have lawyers.
Yeah.
Not often, and I think it also goes to this effect that with a high number, let's say it's a really, really high number, what's going to ultimately happen is that the other side will mimic that behavior and offer a very, very little number. That's
Yep.
their jerk reaction back. And then we have this micro moves that
Mm-hmm.
takes forever and it
Takes forever.
frustrates everybody. So if
Exactly.
we were more efficient and offered like you know, good reason numbers allows you to the ability to still negotiate, but without being excessive.
Hmm. Well, I mean, I bring up the whole lawyer versus non-lawyer thing is because I think the lawyers, who do this all the time, they kind of know what's reasonable, okay, and where they think the case might get settled. But if you're dealing with people who don't have an attorney, um, it's like Wild Wild West. It sometimes you're getting things that make zero sense, and not to say that people who don't have lawyers can't adequately represent themselves. I'm not saying that for people out there. However, I just think sometimes people without attorneys might start off at a place that might not seem reasonable unless they had counsel.
And
All right.
oftentimes I'll
Mhm.
see in my mediations, if that happens, somebody offers a really big number and then the typical little number comes back in response, halfway through the mediation, eventually they will get to a number where the defense side will say, oh, finally they're starting where they should have started.
Yeah.
But it took us 2 hours to get there.
Yeah.
Right?
Yeah. Totally with you on that. Okay. Number 7. Share information with the other side so they can see the case more like you. It's a good point. So why is that important?
Well, that is the only way where you're going to try to find some overlap to bridge the difference in my mind. Typically what happens, and again, I say this during my opening presentation, is that as human beings, it's natural that we're only going to assert and be worried about our position only, right? This is my view. This is my case. These are my things. This is my argument. And then you turn a blind ear to what the other side is saying. That's not real helpful because it's going to take both of you to resolve this case. And the only way to do that is to try to convince the other side. And obviously, there's an art to that, but share information so that they can see, well, you know what? That kind of makes sense. I don't have to agree with it, but I see where you're going. I can see how somebody else could agree. That's where you start having the interesting conversations. But if you completely block it off and only are concerned with your view particularly, that's where we're already butting heads. That's where the complaint was filed. That's where the answer's filed. You're not making any progress.
Yep, totally with you. So number 8, provide reasoned offers that are not arbitrary. Thank you for saying this one. So why is this one important?
Much like starting off on a reasonable number, the reasoned offers is a little different. It's like, okay, I am making an offer to you based on damages, whatever it is,
Yep.
and have some sort of reason behind it when you move down, or you move up,
Yep.
whatever it may be. This is the support for that.
Correct.
You're just throwing out numbers and it seems quite random. Uh, People will perceive that and it will seem arbitrary and they don't know how to deal with that and they won't like it. And it
Yep.
also creates complexity in the rooms and discussion and confusion, none of which is helpful to trying to solve the problem.
Yep. I've told my clients this many times. We're about to go to mediation, and I tell them, look, if you have a position on something, please give me a reason for it. Actually, I also say it when I'm a mediator for the parties. I'm like, look, don't send me to the other side, with uh, the position on whatever on X that is not without sending me also with some kind of reason as to why. How do you get there? Okay, it needs to make sense. If the other side hears it and they might not agree with your reason, but they hear a rationale as to how you came to that conclusion, then more likely than not, they're going to accept it. But if the other side just, doesn't understand why you would make such a suggestion, it might look like you're playing games. It might look like you're just trying to, upset them. So totally, this is a big one.
Mm-hmm.
Okay, number 9, almost there. Be flexible and willing to compromise by knowing what both sides need for a settlement. Okay, please explain.
Similar to the reasoned offers. So these are kind of interrelated.
Mhm.
Um, you need to understand what the other side needs, right? Again, if you're only going to focus on what you want, it's not going to work. The other side's there as well. They need something too. How do you get them that, whatever that might be?
Yep.
And that may be more appropriate in family law cases when in my cases, a lot of times it's about money, right? So somebody needs money. The other person says, I want to be left alone, make the lawsuit go away,
Yeah.
right? That's simple. But in, like, for instance, in your cases for family law, it could be, okay, who gets the couch?
Yep.
Okay. Who gets to stay in the vacation home? Things like that. But you can't just take everything for yourself. The other person needs something. They need a reason to
Yeah.
resolve the case. So you need to keep that in mind.
Yeah. Otherwise, I'll fight you. Okay. And it'll keep on going. And so you have to see it from their perspective and their point of view as to, what they might want to put down their sword and stop fighting. So I tell people this all the time. And the phrase I've always used is, hey, don't corner the other side. You have to see it from their perspective, because like a caged animal or a cornered animal, they're going to lash out. They're going to fight because they want justice. Okay. And they're going to just push back. They may not be reasonable for it, but that's just human nature. So you have to give the other side a reason as to why they should want to settle. And sometimes that means conceding some things, but definitely seeing it from their perspective. So be flexible and willing to compromise and knowing what they're thinking. Okay. And number 10, last one.
That
Oh, yeah,
one,
go ahead.
you touched upon something that's really interesting,
Yeah.
because there's also lots of literary sources, whether it's psychology, etc., about some of these principles. These are not just pulled out of thin air, right?
Correct.
Sun Tzu wrote about this.
Yep.
Art
Audible.
of
Yeah.
war, right? You
Mhm.
can't put your enemy in a tiny, tiny little corner, like you said, and
Yeah.
expect them just to lay down. They will fight, tooth and nail. So you need to allow an honorable retreat, right?
Mhm.
Options for different ways to go.
Yep. Help people save face, right? Same kind of
Mhm.
thing. Just going on the attack and me, and not letting the other side get a breath is only going to make life more difficult for you. Okay.
Exactly.
It's one of those things. Ah, number 10, last one. Provide your bottom line before leaving mediation. Now, that sounds like it should be obvious, right? Why is that important? Provide your bottom line before leaving mediation.
A lot of times that's not done, right? That's strategic reasons for lawyers that don't want to do it, because if I guess in one hand the thinking would be, if I know it's not going to settle, or at least I don't think it's going to settle, then why give the benefit of what I was willing to do? It doesn't serve any purpose. That's kind of the thought.
Hmm.
In my mind, I see that as a wasted opportunity, because you never know, right? And the reason why this is like a big one for me is that I had several cases like this where I knew that the other side literally told me that they had more money, but it's just not worth it to tell them. They're not going to take it. So let's just call this an impasse, right?
Hmm.
And I said, well, wait a minute. You don't know until they tell you no. And why don't what would be the harm? Try it. Let's see if you're willing to accept that, and they accept it, then it's over. And sure enough, even though there's one case where there's literally a difference of $250, the gap was much larger than that, but they only
Yeah.
had $250 extra. That was offered, and the case settled for that, much to their own surprise. So that's why I always say, do it. You never know. One, and two, it's a wasted opportunity if people don't do it, because at least they know what the options are. And you want to at least, my goal is always for people to at least, it's either a hard choice or an easy choice, right? Hard choice to walk away, or it's an easy choice. Our gap is way too far. I have no other choice but to go to trial. But if you don't at least have those choices, right,
Yeah.
then what's the point? So it's always encouraging to do that. And it's also information, so the parties see how differently they value the case.
Yeah. Clear things up for them. And a lot of times, I don't know about your experience, but when people leave mediation where we've exhausted all these things and there's clarity and people know exactly why there was no settlement, then the next day, oftentimes when people have slept on something and they've thought about it, they've processed it, you sometimes get the call back as a mediator. I've heard it, and people say, "Hey, we're going to come back to you. We want to reconsider this, and we reconsider the other side's positions," or they might work it out themselves without the mediator being involved. So,
Sometimes called the shopping effect.
no,
So
tell me
in
more.
a plaintiff's perspective, the defense offers X,
Yeah,
right? And they're like, no, that's just not acceptable. I can't deal with that.
yeah,
But then, as you said, over the weekend, they think about it and they start
mhm,
pondering, what would I do with that?
Mhm.
I could do this, 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 and this. And all of a sudden, the idea seems a little bit better and nicer to them. And
Yep.
next thing you know, on Monday, they're like, hey, let's do it.
Yep.
So, yes, and you don't know that if you don't put out that number, right?
Exactly. Yeah. So that's a really, really good tip for lawyers out there who are talking to their clients. Don't close doors. Mediation is a way to go. And worst thing that could happen is you say no, and then you go to
Sure.
court, right? Uh, but okay. So Patrick Russell, thank you so much, for being on the LMI podcast today. And gonna share your monitor, your computer screen one more time. And so that's your website, and people can go to meaningful-mediation.com. Meaningfulmediation.com. That's your website, and folks can learn more about you and everything they need to know. And you focus mainly on, I believe there's a list right here. What HOAs, debt collection, real estate mediations, malpractice, liabilities, whether it's personal injury or not. So just a lot of different stuff
Hmm.
for people to go learn. All right, thank you so much, for
Thank
coming
you,
on.
Matt, for having me. It was a great conversation.
Yes, sir. All right, everyone, until next time, come back, lmipodcast.com. Check this out on YouTube, Spotify, Apple Music, Apple Apple Podcasts, I meant, and Amazon Music. Okay. Okay, guys. Take care. Bye bye.